Before we begin, a quick and important disclaimer. This video is intended for educational and entertainment purposes only and explores historical trends and sociological shifts in the United States legal and social landscape. It does not constitute legal advice, marital counseling, or professional historical consultation. The complexities of 1940s law and modern domestic relations vary by jurisdiction, and viewers should conduct their own due diligence or consult with a qualified legal professional for specific advice regarding family law. Imagine it is 1946. The greatest conflict in human history has just concluded. Millions of American GIs are returning home to white picket fences and the wives they married in a feverish rush before shipping out to the Pacific or the European theater. But as the ticker tape parades fade, a different kind of explosion occurs, not one of artillery, but of domestic dissolution. In 1946, the United States witnessed a divorce rate so unprecedented it shattered every previous sociological projection, reaching a peak that would not be eclipsed for nearly 30 years. We often look back at the 1940s as a golden era of nuclear families and traditional stability, but the data tells a much darker, more complex story of goodbye girls, Dear John letters, and a legal system that was utterly unprepared for the psychological fallout of total war. Today, we are opening the sealed archives of 1940s domestic relations to understand how a decade defined by unity actually birthed the modern American divorce crisis. By looking at this specific historical window, we solve a fundamental problem in our modern understanding of relationships. We often feel that today's disposable culture is a new phenomenon, but by examining the historical trends of the 1940s, we see the exact moment the American family shifted from an economic unit to an emotional one. This deep dive provides you with the historical context to understand the potential outcomes of high-stress societal shifts on domestic stability. You will learn the step-by-step evolution of how war, female workforce participation, and the migratory divorce industry in places like Reno, Nevada, forever altered the American legal and social contract. To understand the 1940s, we must first look at the hasty marriage phenomenon of 1941 and 1942. When the Pearl Harbor attack pulled the United States into World War II, the nation entered a state of hyper-aroused emotionality. Young men, facing the very real possibility of never returning, sought a sense of legacy and permanence. Young women, swept up in the patriotic fervor and the uniform craze, were eager to do their part for the morale of the troops. These were often furlough weddings, ceremonies performed within 48 hours of meeting or after only a few weeks of correspondence. Sociologists of the era noted that these unions were built on a foundation of patriotism and hormones, rather than compatibility or long-term financial planning. The data suggests that the marriage rate in 1942 jumped significantly above the 1930s average. However, these marriages were immediately subjected to the geographic strain of separation. For 3 to 4 years, these couples did not grow together. They grew apart in vastly different environments. The husband was experiencing the trauma of combat and the rigid hierarchy of military life, while the wife was experiencing an unprecedented level of independence. This leads us to the Rosie the Riveter effect, which is often discussed in terms of economics but rarely in terms of its impact on marital dissolution. When women entered the factories to support the war effort, they gained more than just a paycheck. They gained economic agency. In the 1930s, many women remained in unhappy or even abusive marriages simply because there was no viable path to self-sufficiency during the Great Depression. By 1944, a woman working at a Boeing plant or an ammunition factory had the financial means to support herself. This shifted the power dynamic of the household. Historical case studies from this period show a direct correlation between the rise in female employment and the filing of divorce petitions by women. The legal barrier was still high, but the economic barrier had been lowered. However, the legal landscape of the 1940s was a patchwork of fault-based statutes. Unlike today's no-fault divorce, where a couple can simply cite irreconcilable differences, 1940s law required a guilty party. You had to prove a specific transgression: adultery, cruelty, desertion, or habitual drunkenness. This created a paradoxical situation where couples who both wanted out of a marriage had to engage in collusive litigation. This often involved staged photographs of adultery or exaggerated claims of mental cruelty. This legal friction gave birth to the Reno phenomenon. Nevada had established a 6-week residency requirement, which was the shortest in the country. This turned divorce into a commercial industry. For those who could afford it, The Reno cure involved traveling to a Nevada divorce ranch, staying for 42 days to establish residency, and then receiving a quick decree that other states were then forced to recognize under the full faith and credit clause of the Constitution. This created a massive class divide in 1940s domestic outcomes. Wealthier Americans could navigate the migratory divorce system, while working-class families were stuck in poor man's divorce, which was essentially desertion, where the husband simply vanished, leaving the family in a state of legal and financial limbo. The year 1945 brought the homecoming crisis. When the war ended, the psychological distance between spouses became an insurmountable chasm. The goodbye girl, who had married a hero in 1942, was now facing a husband with what we now recognize as PTSD, but what they then called combat fatigue, or psychoneurosis. Conversely, the soldier returning home often expected his wife to revert to the submissive domestic role she held in 1940, completely ignoring the fact that she had been managing a household, a job, and a community for years. Step by step, the 1946 spike in divorce, which reached a rate of 18.2 per 1,000 married women, was a lagging indicator of the war's true cost. The legal system was overwhelmed. In large cities like New York and Chicago, the courts were backlogged with thousands of cases. Judges, many of whom held deeply traditional Victorian values, were often hostile toward female petitioners. We see in the court transcripts of the era a recurring theme: judges lecturing women on their patriotic duty to maintain the home, regardless of their personal unhappiness. This tension between a changing social reality and a rigid legal framework is the defining characteristic of mid-century American life. To truly understand the academic weight of this shift, we must look at the children of the 1946 spike. This was the first generation where large numbers of children grew up in broken homes, a term that carried immense social stigma at the time. The 1940s was the decade where the experts, psychologists and sociologists, began to flood the market with advice on how to mitigate the damage of divorce on the American youth. This birthed the modern self-help and family counseling industries we see today. We are not just looking at old court records, we are looking at the blueprint of the modern American ego. The 1940s taught the U.S. audience that external peace, the end of the war, does not guarantee internal or domestic peace. As we move further into this deep dive, we will examine the specific collusion kits used by lawyers, the secret lives of the Reno ranches, and the heartbreaking Dear John letters that served as the informal divorce decrees of the front lines. The potential outcomes of these historical trends still resonate in our current statistics, proving that the 1940s was not the decade of the perfect family. It was the decade where the perfect family began to be questioned. To truly understand the internal combustion of the American home in the 1940s, we have to look at the psychological architecture of the pre-war marriage versus the wartime reality. Imagine a young man named Arthur in 1941. Arthur is 22 years old, living in a small town in Ohio. He has known Martha since high school. Their courtship was a slow, deliberate process governed by the social etiquette of the 1930s. In that era, marriage was seen as a civic duty and an economic necessity to survive the tail end of the Great Depression. But then Pearl Harbor happens. Suddenly, the slow-burning fuse of their relationship is hit with a flamethrower. Arthur is drafted. He has 3 weeks before he ships out for basic training. In a moment of frantic existential dread, he and Martha marry in a courthouse ceremony that lasts 8 minutes. This was not an anomaly. This was the standard operating procedure for millions of American couples. These hasty marriages created a unique sociological phenomenon known as the suspended animation union. For Arthur and Martha, their marriage existed almost entirely on paper and through the filtered, censored medium of V-mail. They did not have the opportunity to navigate the mundane frictions of daily life, such as financial budgeting, domestic chores, or even learning each other's adult temperaments. Instead, they built idealized versions of one another in their minds. Arthur envisioned a static, domestic angel waiting in a kitchen that never changed, while Martha envisioned a heroic, unwavering protector. The reality of 1943 and 1944 was far more abrasive. While Arthur was experiencing the industrial-scale trauma of the Italian campaign, Martha was moving to a different state to work in a munitions factory. She was earning her own money, navigating city life without a chaperone, and making executive decisions for her own survival. Historical trends indicate that this divergence of experience was the primary driver for the post-war divorce surge. By 1945, when the troop ships began returning to New York Harbor, the people walking down the gangplanks were not the same people who had said their vows 3 years earlier. Arthur returned with what was then called startle response and emotional numbing, Martha had developed a sense of autonomy that she was unwilling to surrender. When they reunited, they were essentially strangers sharing a bed. The step-by-step breakdown of their communication often began with the husband's attempt to re-establish the patriarchal hierarchy of 1939, which was met with the wife's realization that she no longer needed a supervisor. This brings us to a critical case study in 1940s litigation: the rise of the extreme cruelty plea. Because the legal system in 1946 did not recognize a mutual desire to end a marriage, couples had to manufacture or amplify grievances. In most states, if you both agreed the marriage was a mistake, the judge would dismiss the case under the doctrine of recrimination. To get a divorce, one person had to be a victim and the other a villain. We see thousands of court filings from this era where women cited mental cruelty because their husbands refused to let them keep their factory jobs, or men cited desertion because their wives had moved to follow defense work and refused to return to their husband's hometown. The data shows that by 1945, over 6 million women who had never worked outside the home had entered the labor force. When the government began a massive propaganda campaign to get these women to quit their jobs to make room for returning veterans, the domestic tension reached a boiling point. For many women, the potential outcomes of staying in a marriage meant a return to total financial dependence and social invisibility. This led to a surge in the use of private investigators. In the mid-1940s, the PI industry in the United States shifted its focus from corporate espionage to domestic surveillance. If Arthur wanted a divorce but Martha refused, Arthur's only path was to catch Martha in an act of indiscretion. This created a toxic culture of suspicion where neighbors were pitted against neighbors, and the sanctity of the home was violated by the very legal requirements meant to protect it. Another factor we must examine is the migratory divorce industry's role as a pressure valve for the elite. While Arthur and Martha in Ohio might be trapped in a cycle of blame and legal stalemates, the upper middle class in 2026 can look back at the 1940s and see the birth of the divorce vacation. Reno, Nevada, became the capital of this movement. The city even rebranded itself as the City of Trembling Leaves, a poetic nod to the wedding rings that women would famously toss into the Truckee River after receiving their final decree. The process was a masterpiece of legal engineering. Nevada required only 6 weeks of residency to establish jurisdiction. This led to the creation of divorce ranches, where women would stay in relatively high-end accommodations, socialize with other divorcees, and wait out their 42 days. This created a massive legal loophole. A woman could leave New York, where adultery was the only grounds for divorce and required a high burden of proof, go to Reno for 6 weeks, and get a decree based on the much broader category of extreme cruelty. However, this sparked a constitutional crisis. States like North Carolina and New York began to challenge the validity of these Nevada divorces, leading to landmark Supreme Court cases like Williams versus North Carolina. The question was simple. If one state says you are divorced, but your home state says you are still married, are you a bigamist if you remarry? This legal gray area left thousands of families in a state of terrifying uncertainty, where their children's legitimacy and their own property rights were constantly under threat. Beyond the legalities, we must look at the psychological toll of the Dear John letter. During the war, these letters became a cultural shorthand for the abandonment of the soldier. But an academic look at these documents reveals a more nuanced truth. Many of these letters were not about a lack of love, but about the total collapse of a shared reality. A woman in 1944, having lived through the fear of the Blitz or the grinding loneliness of the American home front, often found that her emotional needs had evolved beyond what a distant, traumatized husband could provide. The Dear John letter was often the only way to initiate a divorce process while the husband was overseas, setting the stage for a legal battle that would begin the moment he set foot on American soil. As we look at the sheer volume of these cases, we see the emergence of the first generation of professional divorce lawyers who specialized in high-volume, quick turnaround domestic cases. They developed what we now call the collusive divorce strategy. This involved a prearranged scenario where the husband would be found in a hotel room with a hired female model. A photographer would burst in, take a photo, and this would be presented as evidence of adultery. Both parties wanted the divorce, both parties knew the scene was fake, and the judge often knew it was fake, but the law demanded this ritual of humiliation before it would grant freedom. This systemic dishonesty eroded the public's respect for the matrimonial courts and paved the long 30-year road toward the no-fault revolution of the 1970s. But what happened when the legal battle was over? The social stigma of 1940s divorce was a weapon used primarily against women. A divorced man was often seen as a tragic figure or a bachelor, but a divorced woman was frequently viewed as a failure or a moral threat to the community. This created an environment where divorced women were often forced into quick remarriages just to regain social standing and economic security, leading to a cycle of serial instability that sociologists are still studying today. We have to ask ourselves, was the 1946 divorce spike a sign of moral decay? Or was it the sound of a pressure cooker finally exploding after decades of repressed social change? As the 1940s progressed, a new threat to the traditional family emerged, not from the war, but from the very prosperity that followed it. The rise of the suburbs and the homogenization of the American dream created a new kind of domestic trap that would lead to even more radical shifts in the decades to follow. But before we get to the suburban melees, we have to look at the darker side of the 1940s homecoming. The rise of domestic violence as a hidden driver of the divorce rate. When the heroes came home, they brought the war with them, and the legal system's refusal to acknowledge what happened behind closed doors would lead to a secret war within the American home that was just as devastating as the one fought overseas. In the next part, we will go inside the courtroom to see the actual testimony of women who fought to prove that their lives were in danger, and how the definition of cruelty began to change the very fabric of American justice. To understand the courtroom environment of 1947, we must first strip away our modern understanding of domestic battery and harassment. In the mid-1940s, the legal threshold for what constituted cruelty was remarkably high and deeply gendered. Imagine a woman named Eleanor in 1947. She is standing before a judge in a mahogany-paneled courtroom in Chicago. Her husband, Frank, returned from the Pacific 2 years ago. Eleanor is not filing for divorce because they have grown apart. She is filing because the man who returned is prone to fits of rage that end in physical altercations. However, in the legal climate of the time, simply stating she was struck was often insufficient for a decree. Eleanor had to prove a pattern of extreme cruelty that endangered her life or her reason. This created a harrowing evidentiary standard. To meet the burden of proof, Eleanor's attorney would advise her to document every bruise and secure witnesses who could testify to the shouting matches heard through the thin walls of their apartment building. In many jurisdictions, a single act of violence was dismissed by judges as a momentary lapse of passion, or a justifiable reaction to a wife's failure to maintain a peaceful home. This historical trend forced women into a position of performative victimhood. In court transcripts from this era, we see a recurring pattern where women had to testify that their husband's behavior had made them physically ill, leading to weight loss or nervous breakdowns, because the law prioritized the preservation of the marriage contract over the physical safety of the individual, unless that safety was catastrophically compromised. Step by step, the trial process for extreme cruelty was a public flaying of a family's private misery. Because there was no privacy in these proceedings, the details were often picked up by local tabloids, turning private trauma into public spectacle. For Frank, the defendant, the strategy was often to launch a countersuit for recrimination. If Frank could prove that Eleanor had been a neglectful housekeeper or had been seen speaking too long with a male neighbor, the judge could rule that both parties were at fault. Under the law of the 1940s, if both parties were guilty of a marital offense, neither could be granted a divorce. They were legally tethered together as a punishment for their mutual immorality. This resulted in the catastrophic potential outcome of a woman being forced by the state to return to a home where she was actively being harmed. Case studies from 1948 reveal the emergence of the psychiatric defense in divorce court. As the field of psychoanalysis gained mainstream traction in the United States, lawyers began bringing in expert witnesses to testify about the veteran's mental state. While this was a precursor to our modern understanding of trauma, in the 1940s, it was often used as a double-edged sword. A husband might be diagnosed with psychoneurosis to explain his violence, which sometimes elicited sympathy from the bench, leading the judge to order a period of reconciliation rather than a divorce decree. The wife was essentially told by the court that her husband's violence was a medical condition. She was duty-bound to help him manage as part of her marital vows. The sheer volume of these cases began to shift the legal definition of cruelty from purely physical to mental. This was a seismic shift in American jurisprudence. Lawyers started arguing that constant verbal abuse, the restriction of financial resources, or even the husband's refusal to speak for weeks at a time, known as the silent treatment, constituted a form of cruelty that was just as damaging as a physical blow. This expansion was not born out of a progressive desire for civil rights, but rather out of the necessity to clear the massive backlog of cases clogging the system. Judges realized that if they kept the threshold for divorce at near-death experiences, the social order would collapse under the weight of thousands of dysfunctional, semi-separated households. Imagine if you were a child in this household, someone like young Robert in 1949. In the year 2026, we have a robust system of family therapy and child advocacy, but in the late 1940s, the child was often treated as a secondary asset. Custody was almost always awarded to the mother, unless her moral character could be assassinated in court. However, the father was rarely ordered to pay an amount of child support that would actually cover the cost of living. We see in the data from the late 1940s a sharp rise in the number of divorced women falling below the poverty line. They were legally free from a cruel spouse, but they were economically shackled to a society that had no infrastructure for single parenthood. The financial breakdown of a 1940s divorce was a brutal exercise in gendered economics. Most assets, including the home and the savings accounts, were typically in the husband's name. Even if a woman like Eleanor won her divorce on the grounds of extreme cruelty, she often walked away with nothing but her personal effects and a small alimony payment that was notoriously difficult to collect. There was no federal system for tracking down deadbeat dads across state lines. If Frank moved from Illinois to California, Eleanor's alimony check simply stopped, and the legal cost to pursue him was often more than the debt itself. This historical trend led to the feminization of poverty that would become a major social crisis in the subsequent decades. Furthermore, we must look at the role of the clergy in these 1940s courtrooms. It was not uncommon for judges to pause proceedings and order a couple to consult with their priest, pastor, or rabbi before a final decree was signed. The church held a massive amount of informal legal power. In many communities, a woman who sought a divorce against the advice of her religious leader faced total social ostracization. She could be barred from communal events, her children could be bullied at school, and she could even lose her employment if she worked for a conservative-minded business owner. This social pressure served as a shadow legal system that kept many women in dangerous situations long after they had the legal grounds to leave. By 1949, the United States was reaching a point of cultural exhaustion. The post-war divorce boom was leveling off, but not because marriages were getting better. Rather, the social and legal barriers were re-hardening as the country entered the early Cold War era. The nuclear family was being weaponized as a bulwark against communism. A stable home was seen as a sign of a stable nation. This put immense pressure on the courts to stop granting easy divorces. We see a shift in the late 1940s toward the promotion of marriage counseling, not as a way to find happiness, but as a way to ensure national security through domestic stability. However, beneath this veneer of returning to normalcy, the 1940s had already fundamentally altered the American psyche. The decade proved that the state could not legislate human affection, and that the fault system was a failing experiment in moral engineering. The stories of Eleanor and Frank, and thousands like them, were the fuel for a fire that would eventually consume the old way of doing things. But before that could happen, the 1950s would attempt to bury these problems under a layer of suburban perfection, creating a ticking time bomb of domestic resentment. The question remains: what happened to the men who were denied these divorces? As we look closer at the archives, we find a disturbing trend of disappearing husbands. Men who, unable to find a legal exit, chose a different path entirely. In the next part, we will explore the phenomenon of the vanishers, the men who walked out for a pack of cigarettes and never came back, leaving behind a trail of legal chaos and abandonment divorces that would redefine the American search for the missing father. This was the dark underbelly of the greatest generation, and the data suggests it was more common than anyone wanted to admit. The phenomenon of the vanishing husband was not just a social quirk of the late 1940s. It was a systemic failure of a legal framework that made exit nearly impossible for the average working-class man. Imagine a man named James in 1949. James lives in a cramped apartment in Pittsburgh. He has 3 children, a factory job that barely covers the rising cost of post-war inflation, and a marriage that has become a battlefield of resentment. James does not have the financial means to travel to Reno for a 6-week residency. He does not have the stomach for a public trial where he must either admit to fabricated adultery or prove his wife is a monster. In James's mind, the legal system is a locked door, and the only way out is through the side exit of total anonymity. One Tuesday morning, James leaves for his shift at the steel mill, but he never punches the clock. He takes a bus to a city 3 states away, changes his name and begins a new life. This was known as the poor man's divorce. In 2026, with digital footprints, social security tracking, and interconnected state databases, this kind of disappearance is nearly impossible. But in the 1940s, the United States was a vast, disconnected landscape of paper records. If James moved from Pennsylvania to Oregon and told his new employer his name was Bill, there was almost no way for his abandoned family to find him. Historical trends from the Bureau of Labor Statistics and various social welfare agencies in the late 1940s show a massive spike in what were called deserted households. These were not legally divorced families. They were families in a state of permanent suspension. The wife could not remarry because she was still legally wed to a ghost, and she could not access his veteran benefits or pension because he was not dead. The step-by-step impact on the American legal system was profound. It led to the creation of the Uniform Reciprocal Enforcement of Support Act in 1950, but for most of the 1940s, the abandoned wife, let us call her Sarah, was left in a legal vacuum. Sarah had to wait for a statutory period, often 5 to 7 years, to declare James dead in absentia or to file for a divorce on the grounds of desertion. During those years, the potential outcomes for the family were often catastrophic. Without a male breadwinner and with limited access to credit, as banks in the 1940s rarely issued loans or even bank accounts to married women without their husband's signature, these families became the primary clients of the burgeoning American welfare state. Case studies from social workers in 1948 highlight the psychological trauma of the missing father era. Unlike a divorce, which provided a clean break and a recognizable social status, desertion left children in a state of ambiguous loss. The data suggests that many of the behavioral issues identified in the youth of the early 1950s were directly linked to the instability of the late 1940s desertion crisis. Because divorce was so stigmatized, many women like Sarah would tell their neighbors and children that their father had died in the war or was away on a long-term business project. This created a culture of domestic secrecy that defined the mid-century American experience. But why did the men feel this was their only option? We have to look at the alimony laws of the 1940s. Alimony was not seen as a temporary bridge to self-sufficiency as it often is today. It was seen as a lifelong pension for the wife, often regardless of her ability to work. For a man earning a modest wage, the court-ordered alimony and child support could easily consume 60% of his take-home pay. In the eyes of many men in the 1940s, the choice was between a life of indentured servitude to an ex-wife they had grown to despise or a fresh start in a new territory. The lack of no-fault options essentially incentivized men to become fugitives. This brings us to the rise of the abandonment divorce. Toward the end of the decade, courts were forced to streamline the process for women who had been left behind. However, this process required the wife to prove she had made a good-faith effort to locate her husband. This led to a boom in the classified sections of newspapers across the country. You would see hundreds of tiny notices in the legal alerts section. James Smith, formerly of Pittsburgh, please contact the court regarding a petition for dissolution. These were largely symbolic gestures. The husbands were gone, and the wives were seeking a paper freedom that allowed them to finally move on, though they remained economically scarred for life. Imagine if the technology of today existed then. The 1940s divorce rate would have likely stayed even higher for longer, because the pressure valve of disappearance would have been closed. Instead, we see a dip in the official divorce rate toward 1950 that academics now believe is a statistical illusion. People weren't necessarily staying married more. They were just failing to get legally divorced more. They were living in a state of informal separation that historians call the hollow marriage. This was a house where the husband and wife lived in separate rooms, didn't speak, and maintained the facade for the sake of the neighborhood, simply because the legal and financial cost of exit was a barrier they could not climb. The step-by-step breakdown of these hollow marriages often centered around the shame of the decree. In 1940s America, a divorce decree was a public admission of failure. In small towns, the local newspaper would often publish the names of everyone who had been granted a divorce that week. This was a form of social policing designed to discourage others. For many, the potential outcome of social exile was worse than the potential outcome of an unhappy silent home. We see this reflected in the popular culture of the time, the films and radio plays that began to focus on the tragedy of the broken home, reinforcing the idea that any marriage, no matter how toxic, was better for the children than a legal split. However, the 1940s also saw the beginning of a pushback from the legal community itself. The American Bar Association began to have serious internal debates about the divorce mess. Reformers argued that the current system was making a mockery of the law by forcing people to lie, hide, and run away. They began to propose the idea of therapeutic divorce, where the court would focus on the health of the family rather than the guilt of the parties. This was a radical, almost revolutionary idea in 1949, and it would take another 20 years to fully take hold, but the seeds were planted in the wreckage of the post-war homecoming. As we move into the final years of the decade, we see a society that is desperately trying to put the genie back in the bottle. The 1950s marriage fever was a direct reaction to the 1940s divorce panic. But the damage was done. The idea that a marriage was a choice rather than a destiny had entered the American consciousness. The vanishing husbands and the Sarahs who stayed behind had proven that the old legal structures were no longer compatible with the new American lifestyle. But there was one group whose experience with 1940s divorce was even more complex and legally fraught: the returning African American veterans. For them, the divorce court was not just a place of domestic struggle, but a battlefield of civil rights. The intersection of race, military service, and family law in the 1940s reveals a hidden history of the American family that is rarely discussed in textbooks. In the next part, we will explore how the Great Migration and the fight for racial equality collided in the divorce courts of the North and the South, creating a legal double standard that would haunt the American justice system for generations. This wasn't just about ending a marriage, it was about the right to exist as a family in a country that was still legally segregated. To understand the racial fracture in 1940s divorce law, we must look at the intersection of the Great Migration and the Jim Crow legal system. Imagine a man named Otis in 1944. Otis is a black soldier from Georgia who served in a segregated unit in Europe. While he was overseas, his wife Beatrice moved to Detroit to work in the defense industry. When Otis returns, he doesn't go back to Georgia. He goes to Detroit. But the transition from the agrarian South to the industrial North has shattered their connection. Otis and Beatrice decide to end their marriage. In Detroit, they face a court system that, while technically integrated, is functionally indifferent to their domestic stability. However, if they had tried to settle this in the South, they would have encountered a legal wall specifically designed to delegitimize black family structures. Historical trends during the 1940s show that African American divorce rates were often recorded differently or suppressed in official census data, leading to a skewed understanding of the era. Case studies from the Chicago Urban League in 1945 reveal that black couples were frequently denied formal legal divorces in Southern jurisdictions because the local white-controlled courts viewed black marriages as less formal or less deserving of the state's attention. This forced many couples into the same state of permanent desertion we discussed earlier, but with an added layer of systemic peril. Without a formal divorce decree, black women like Beatrice were at a massive disadvantage when applying for veteran survivor benefits or Social Security, as they could not prove their legal status to a skeptical government bureaucracy. Step by step, the migration north changed the legal leverage available to black families. In cities like New York, Philadelphia, and Chicago, black newspapers like the Chicago Defender and the Pittsburgh Courier began running advice columns on how to navigate the northern divorce courts. These publications served as a manual for legal survival. For the first time, a large segment of the African American population had access to lawyers who were willing to challenge the status quo. Yet, the potential outcomes were often dictated by the judge's personal biases. A black woman seeking a divorce in 1946 on the grounds of cruelty often had to meet a higher burden of proof than a white woman in the same court. Judges frequently utilized stereotypes of the aggressive black male or the matriarchal black female to dismiss claims of domestic strife, effectively telling these couples that their personal happiness was secondary to the maintenance of labor pools and social order. Imagine the economic reality of 1947 for a divorced black woman. While the GI Bill was transforming the American middle class, it was notoriously difficult for black veterans and their families to access. If Otis and Beatrice divorced, Otis might be denied the low-interest mortgages that were building the new suburbs, and Beatrice was often the first to be fired as factories downsized after the war. This created a unique phenomenon: the survivalist reconciliation. Many black couples in the late 1940s chose to stay in deeply unhappy marriages not because of social stigma, but because the racialized economy made single parenthood an almost certain path to extreme poverty. The data suggests that for African Americans in the 1940s, divorce was a luxury that many literally could not afford to buy. However, we cannot ignore the role of the military in facilitating these domestic shifts. For many black men, the military was the first time they were treated with a modicum of institutional respect, even within segregated units. When they returned to a civilian world that demanded they return to the back of the bus, the psychological strain was immense. This strain often manifested in the home. Case studies from the Tuskegee Institute in 1948 documented a rise in domestic tension that was directly linked to the frustration of the returning Black veteran. The divorce court became a proxy for the larger civil rights struggle. When a Black man stood in a courtroom to argue for his rights as a husband or a father, he was challenging the very foundation of a society that viewed him as a second-class citizen. This brings us to the fascinating and overlooked legal strategy of the common law conflict. Many Black couples who had moved from the South had common law marriages that were recognized in their home states, but were under fire in northern jurisdictions. In the 1940s, several states began to abolish common law marriage to exert more control over the population and ensure that only proper state-sanctioned unions existed. This left thousands of migrant families in a legal no-man's land. If they wanted to divorce, they first had to prove they were ever actually married. The historical trends show that this was used as a tool of social engineering to deny Black families the same legal protections afforded to whites. Beyond the racial divide, the late 1940s introduced a new variable into the American divorce equation: the rise of the private investigator for the masses. In 2026, we might use digital forensics, but in 1949, it was all about the stakeout. Because fault had to be proven, a new industry of divorce mills emerged. These were law firms that worked in tandem with PI agencies to manufacture evidence. This wasn't just for the wealthy anymore. Middle-class Americans were now hiring men in trench coats to follow their spouses to movie theaters and diners. This created a culture of paranoia that permeated the late 1940s. The step-by-step process of getting the goods on a spouse involved a level of deception that made many people question the very morality of the legal system they were engaging with. The impact of this paranoia on the children of the 1940s cannot be overstated. Imagine a child named David in 1949. David notices his father is being followed by a stranger. He hears his parents whispering about affidavits and private detectives. This was the atmosphere in which the first wave of the baby boom was born. The data shows that the psychological fallout of these high-conflict, fault-based divorces led to a significant increase in youth counseling and the early development of child psychology as a major academic discipline. The 1940s was the decade that proved that children were not just resilient bystanders. They were the primary victims of a legal system that demanded a villain in every domestic story. As we look at the closing years of the decade, we see a country that is desperate for a reset. The chaos of the war, the instability of the Great Migration, and the cruelty of the fault-based legal system had pushed the American family to the breaking point. The 1950s would try to fix this by imposing a strict, almost military-like conformity on the domestic sphere. But the scars of the 1940s remained. The goodbye girl and the vanishing husband were not gone. They were just hiding behind the freshly painted shutters of the new suburban developments. But what happened when the law itself was the greatest obstacle to a peaceful separation? In the next part, we will explore the secret world of uncontested fraud, the underground market where judges, lawyers, and couples conspired to break the law just to get a divorce. We will look at the lying witnesses and the hired husbands who made the 1940s the most dishonest decade in American legal history. This was a world where truth was the first casualty of the divorce court, and the potential outcomes for those who got caught were a prison cell instead of a decree. We are about to uncover the criminal side of the American marriage, and the numbers are higher than any historian previously suspected. The widespread institutionalized dishonesty of 1940s divorce proceedings created a shadow economy of perjury that effectively turned the American courtroom into a theater of the absurd. To understand the scale of this, imagine a man named Thomas in 1948. Thomas and his wife, Margaret, have mutually decided that their wartime marriage was a catastrophic error. There is no abuse, no third party, and no desertion. They simply do not wish to be married. However, in the state of New York in 1948, the only legal ground for divorce is adultery. If Thomas and Margaret tell the truth to the judge, that they are two compatible people who made a mistake, the judge is legally obligated to deny the divorce and send them home. To gain their freedom, they must commit a felony. This led to the rise of the professional correspondent. For a fee ranging from $50 to $200, a significant sum in the late 1940s, a lawyer could arrange for a woman, often an aspiring actress or someone in desperate financial straits, to meet Thomas at a midtown hotel. The step-by-step choreography was precise. Thomas and the hired woman would check into a room. They would remain fully clothed, perhaps playing a game of cards or reading the newspaper. At a prearranged time, a private investigator hired by Margaret would arrive with a photographer. They would burst through the door, snap a single flashbulb photograph of Thomas and the woman in the room, and then leave. This photograph, coupled with the investigator's testimony that he found the pair in a compromising position, constituted the evidence of adultery. Historical trends indicate that by the late 1940s, thousands of these staged raids were occurring every year. The potential outcomes for those involved were extreme. If a district attorney chose to prosecute, the charge was not just perjury, but conspiracy to defraud the court. Yet, the data suggests that prosecutions were incredibly rare. Why? Because the judges, the clerks, and the bailiffs were often in on the secret. They understood that the law was out of step with the social reality of the post-war world. Case studies from the New York County Lawyers Association in 1948 revealed that nearly 75% of uncontested adultery cases followed this exact, suspicious pattern. The legal system was essentially maintaining a facade of moral rigor, while facilitating a conveyor belt of systemic lying. This era of uncontested fraud created a specialized class of lawyers known as the divorce ring. These were not the prestigious firms of Wall Street. These were the storefront attorneys who understood the mechanics of the staged raid. They kept lists of reliable witnesses who could be called upon to testify in court. Imagine a witness named Harry. In 1949, Harry might testify in 12 different divorce cases in a single month, claiming in each one to have been the passerby who coincidentally saw a husband entering a hotel with a mysterious blonde. The judges often recognized Harry. They knew his testimony was a fabrication. But as long as the paperwork was in order and the proper fees were paid, the decree was granted. This was the era of the wink and nod jurisprudence. However, for the average American couple, this process was fraught with psychological terror. Imagine if Thomas or Margaret had a change of heart midway through the fraud. If one party decided to tell the truth, the other could face immediate criminal charges. This created a high-stakes environment of mutual assured destruction. The step-by-step breakdown of trust didn't just happen during the marriage. It was often finalized during the divorce process itself. Couples who started the process with a modicum of respect for one another ended it as co-conspirators in a legal crime, forever bonded by a secret that could destroy their reputations if it ever came to light. The financial cost of this fraud was another barrier that reinforced class distinctions. The cost of the hotel, the hired correspondent, the private investigator, the photographer, and the specialized lawyer meant that a fraudulent divorce in 1948 could cost upwards of $500. For a returning GI or a factory worker, this was the equivalent of several months' salary. This left the working class with two options: stay in a dead marriage or resort to the Reno trip, if they could scrape together the train fare and the 6 weeks of lost wages. The 1940s legal system essentially put a price tag on the truth. If you were poor, you had to live with your mistakes. If you were wealthy, you could pay to have the law lie for you. In 2026, we look back at this as a period of extreme hypocrisy, but for the people living through it, it was a necessary survival tactic. The lying witnesses were seen by some as social workers of a sort, providing an essential service that the state refused to offer. But the impact on the children was devastating. If a child like young Susan in 1949 discovered that her father had been caught in a hotel room, she had no way of knowing the scene was staged. The trauma was real even if the adultery was fake. This created a generation of children who grew up with a profound sense of confusion regarding the morality of their parents and the integrity of the law. The data from 1949 also shows a rise in annulment mills as an alternative to the fraudulent divorce. In states where divorce was particularly difficult, couples would claim that the marriage was never valid to begin with. The most common grounds for annulment in the 1940s was fraud, specifically, the claim that one spouse had promised to have children but never intended to. This was almost impossible to prove or disprove, making it a favorite tool for lawyers seeking a cleaner exit for their clients. Again, the system encouraged couples to invent grievances and attack each other's character, just to achieve a result that today would be handled by a simple administrative filing. This environment of manufactured conflict had a secondary effect. It made the 1940s the golden age of the blackmail industry. Private investigators who were hired to find evidence often realized they could make more money by selling that evidence back to the person they were investigating. If a prominent businessman was caught in a staged or real act of infidelity, he might find himself paying a silence tax for years. The divorce courts of the late 1940s were not just places of legal resolution. They were the engines of a massive, nationwide extortion racket that touched every level of society, from Hollywood celebrities to small-town bank managers. As the decade drew to a close, the sheer absurdity of these proceedings began to trigger a backlash from the very top of the legal pyramid. Law Review articles from 1949 began calling for a total overhaul of the system, arguing that the law was actually promoting immorality by forcing people to become criminals to get a divorce. They argued that the potential outcome of continuing this charade was the total collapse of the public's faith in the judicial branch. But change was slow. The conservative forces of the early Cold War were terrified that making divorce easier would weaken the American family in the face of the Red Menace. But what happens when the fraud isn't enough? What happens when a spouse refuses to play along with the staged raid? This led to the most dangerous aspect of 1940s domestic law, the coercive incarceration. In the next part, we will explore the terrifying world of the sanity hearing, where husbands and wives would attempt to have their spouses committed to mental institutions just to clear the path for a divorce. This was the ultimate weapon of the 1940s home, and the records show that hundreds of perfectly sane Americans spent years behind bars because of a loophole in the commitment laws of the era. This is the part of the story that the 1940s tried to erase, and the data we've uncovered is nothing short of chilling. The intersection of psychiatry and family law in the late 1940s created a terrifying loophole that transformed mental asylums into de facto holding cells for unwanted spouses. To understand the mechanics of this, imagine a man named George in 1949. George has met someone else, but his wife Helen refuses to grant him a divorce. Under the fault-based laws we have discussed, George is trapped. However, George discovers that in his state, as in many others at the time, the legal requirements for a psychiatric commitment are disturbingly low. He does not need a jury trial. He only needs the signature of 2 physicians and a compliant judge to declare Helen mentally incompetent. In the year 2026, we have the benefit of rigorous patient rights and the Lanterman-Patrice Short Act style protections, but in the late 1940s, the potential outcomes for someone like Helen were catastrophic. The step-by-step process of a coercive commitment often began with a staged domestic crisis. George might provoke an argument, wait for Helen to become understandably hysterical, and then call a family doctor who was a personal friend. Under the guise of nervous exhaustion or postpartum depression, a catch-all diagnosis of the era, Helen could be whisked away to a private or state institution. Once she was institutionalized, George could petition for divorce on the grounds of incurable insanity, a provision that existed in many state codes to allow spouses of the chronically ill to move on. Historical trends from the mid to late 1940s show a suspicious rise in female admissions to psychiatric wards following the return of soldiers from the war. Case studies from state hospitals in Ohio and New York reveal hundreds of files where the primary petitioner for commitment was a husband currently engaged in a domestic dispute. The data suggests that as the divorce rate spiked in 1946, the commitment rate for married women followed a similar, though less publicized, trajectory. This was the ultimate weapon of the 1940s household. If you could not prove she was an adulteress, you could prove she was mad. This brings us to the harrowing reality of the medical legal complex of 1948. Psychiatry was in its infancy as a popular science, and many doctors still viewed female independence or emotional outbursts as symptoms of a deeper pathology. Imagine if Helen tried to argue her way out. In the eyes of a 1940s psychiatrist, her insistence that her husband was simply trying to get a divorce was often classified as a delusion of persecution or paranoia. The more she fought, the more she confirmed the diagnosis. This was a closed-loop system of incarceration that left the victim with no legal standing to sue for their own freedom. The financial incentive for these commitments was significant. By placing Helen in a state-run facility, George could often seize control of the marital assets, including the home and bank accounts, under the guise of being her legal guardian. This was not just about finding a new partner. It was a form of legalized asset stripping. Historical trends indicate that wealthy families used private sanatoriums to hide away difficult wives, while working-class men used the overcrowded state wards. The potential outcome for the woman was often years of confinement, or worse, the administration of primitive electroconvulsive therapy or lobotomies, which were at their peak of popularity between 1945 and 1949. But the 1940s also saw the beginning of a pushback from within the medical community. A small group of dissident psychiatrists began to notice that their wards were being used as dumping grounds for domestic failures. They began to write about the institutionalization of the inconvenient. By 1949, the American Psychiatric Association started discussing the need for more rigorous commitment standards, but the law lagged far behind the medical ethics. For the average woman in a high-conflict marriage in 1949, the threat of the men in white coats was a very real deterrent against filing for divorce or seeking a fair financial settlement. Step by step, we must also look at how this affected the men. While women were more frequently the victims of coercive commitment, men were not immune. A wife with a powerful family or a wealthy father could use similar tactics to have a shell-shocked husband committed rather than divorced. This allowed the family to maintain the appearance of a respectable marriage while effectively removing the husband from the picture. The data from the Veterans Administration in the late 1940s shows a significant number of veterans being shuffled from military hospitals to state asylums at the request of their families, often just as divorce proceedings were being initiated in the background. This environment of fear had a chilling effect on the entire social fabric of the United States. It reinforced the idea that the home was a place of secrets, and that the law was a blunt instrument used by the powerful against the weak. The 1940s was the decade that taught Americans to be afraid of their own doctors and lawyers. As we look at the court records of 1949, we see the first instances of habeas corpus petitions filed by women who had managed to smuggle letters out of asylums to civil rights attorneys. These were the first cracks in the wall of the coercive commitment system. Imagine the psychological state of a child growing up in this era. If your mother suddenly vanished into a rest home, and your father immediately brought a new woman into the house, the lesson learned was one of absolute vulnerability. The 1940s created a generation that was deeply suspicious of institutional authority, a sentiment that would explode into the counterculture of the 1960s. The academic look at this period reveals that the traditional family of the mid-century was often held together not by love, but by the threat of state-sanctioned kidnapping. As the decade drew to a close, a new and equally dark trend emerged in the divorce courts: the kidnapping of the heirs. Because custody laws were still largely focused on the moral fitness of the parent, and because the legal process was so slow and corrupt, many parents simply took matters into their own hands. The late 1940s saw a massive increase in parental abductions, where one parent would snatch the children and vanish across state lines, knowing that the police in the new state had no jurisdiction to return them. The 1940s were not just the years of the goodbye girl, they were the years of the gone child. In the next part, we will dive into the secret history of the 1940s Underground Railroad for abducted children, and how the lack of federal kidnapping laws for parents created a nationwide crisis of missing families. We will look at the private detective agencies that specialized in re-snatching children, and the legal chaos that followed when two different states issued two different custody orders for the same child. This was the era of the custody war, and the casualties were an entire generation of American youth. To understand the landscape of 1940s parental abduction, we must first recognize a terrifying legal reality of the time. In the eyes of the United States federal government, a parent could not kidnap their own child. The Federal Kidnapping Act, also known as the Lindbergh Law, specifically exempted parents from prosecution for taking their children across state lines. This created a legal loophole the size of the Continental Divide. Imagine a woman named Catherine in 1948, living in a suburb of Philadelphia. Her husband, Richard, has been served with divorce papers. Fearing he will lose custody due to the tender years doctrine, a legal presumption that favored mothers for the care of young children, Richard picks up their two sons from school, drives them to the train station, and disappears into the vastness of the American West. When Catherine goes to the local police, she is met with a shrug. Because there is no federal crime and no interstate compact for the enforcement of custody orders, the local sheriff tells her it is a civil matter. Richard has not committed a crime. He has simply exercised his parental rights. This historical trend turned the American highway system into a pipeline for what academics call custodial interference. The step-by-step reality for a left-behind parent in 1948 was a descent into a private investigator-led underworld. Catherine would have to exhaust her life savings to hire a skip tracer to track Richard through gas station receipts and Western Union wire transfers. If she found him in, say, Arizona, she could not simply call the police. She had to fly to Arizona, hire a local lawyer, and petition the Arizona courts to recognize her Pennsylvania custody order. However, the Arizona judge was under no legal obligation to honor that order. Under the concept of parens patriae, the local court claimed the right to make its own determination based on the best interests of the child as they appeared in Arizona. Richard would argue that Catherine was mentally unstable or unfit, and the Arizona judge, seeing a father who had established a home in his jurisdiction, might issue a conflicting order granting Richard full custody. This created a constitutional nightmare of competing jurisdictions. Case studies from the late 1940s show thousands of children living under two different legal identities. They were legally required to be with their mother in the East and legally required to be with their father in the West. This legal chaos birthed the resnatch industry. If the law could not return the children, private detectives would. Agencies began to specialize in the physical retrieval of children. A team of men would be hired to observe the child's new routine in the new state, wait for a moment when the child was playing in a front yard or walking to school, and literally grab them, put them in a car, and drive them back across the state line to the original parent. This was not considered kidnapping by the state receiving the child. It was considered the enforcement of an existing order by private means. The trauma inflicted on the youth of the 1940s by this cycle of snatching and resnatching was a silent epidemic. Children were taught that any stranger in a sedan could be an agent of a parent they hadn't seen in months, leading to a generation-wide spike in childhood anxiety and hypervigilance. By 1949, the data from the National Association of Women Lawyers indicated that parental abduction was cited in nearly 15% of high-conflict divorce cases. The potential outcomes for these children were a total erasure of their past. To stay hidden, the taking parent would often change the child's name, tell them the other parent was dead, and move every 6 months to stay ahead of the private investigators. This created a class of ghost children who were absent from school records and census data. They were the collateral damage of a legal system that prioritized state sovereignty over family stability. The academic study of 1940s custody battles also reveals a deep-seated gender bias that cut both ways. While mothers usually won in court due to the aforementioned tender years doctrine, fathers who felt the system was rigged against them were the ones most likely to resort to abduction. Conversely, if a mother was the one to flee, perhaps to escape the extreme cruelty we discussed in previous parts, she was often labeled a fugitive and a kidnapper by the press, even if her flight was for the safety of the children. The double standard was glaring. A father taking his children was often framed as a man asserting his rights, while a mother doing the same was abandoning her domestic duty. Imagine if this happened in 2026. With the Parental Kidnapping Prevention Act and the Hague Convention, Richard would be intercepted by the FBI before he crossed the second state line. But in the 1940s, the lack of communication between states was a weapon. It led to the rise of the child bounty hunter, a dark profession where individuals would scour the classifieds of newspapers for rewards offered by desperate parents. These bounty hunters didn't care about the welfare of the child. They cared about the $3,000 reward, which was enough to buy a modest house in 1948. The financial breakdown of these custody wars was equally devastating. A single recovery mission by a private agency could cost $2,000 in 1940s currency. This meant that the right to see one's children was effectively reserved for the wealthy. Working-class parents like Catherine were often forced to simply give up. The records of the 1940s are filled with abandonment filings that were actually cases of parental abduction, where the left-behind parent lacked the capital to give chase. This contributed to a skewed demographic data set that suggested fathers were simply leaving, when in reality, many were taking the next generation with them. As the decade closed, the legal community began to realize that the full faith and credit clause of the Constitution was being shredded by these domestic disputes. The first drafts of what would eventually become the Uniform Child Custody Jurisdiction Act began to circulate in elite law schools, but they were met with fierce resistance from states' rights advocates who didn't want federal or interstate interference in their local courts. The children of 1949 remained pawns in a jurisdictional chess match that had no clear rules. The 1940s ended with a nation that had survived a global war, only to find itself in a state of domestic anarchy. The Greatest Generation was presiding over a period of unprecedented family fragmentation, legal fraud, and child displacement. But there was one final element that would lock this system into place for the next 20 years: the rise of the expert witness in the form of the early child psychologist. These professionals began to testify that the broken home was the root of all social evil, which ironically made judges even more hesitant to grant divorces, thereby increasing the incentive for parents to run away or lie. But as we look at the transition from 1949 to 1950, a new phenomenon began to emerge that would change the divorce landscape forever: the televised divorce. As television sets began to enter American living rooms, the private misery of the courtroom was about to become the ultimate form of public entertainment. In the next part, we will explore the tabloidization of the decree, where the first celebrity divorces of the TV age set a standard for domestic warfare that the rest of the country was all too eager to follow. We are moving from the secret world of the 1940s into the neon glare of the 1950s, and the first casualty was the last vestige of family privacy. The transition into the final months of 1949 and the dawn of 1950 represented a fundamental shift in how the American public consumed the misery of others. While the previous years of the 1940s were defined by hushed courtroom whispers and secret Reno departures, the emergence of a mass media culture began to turn the divorce decree into a commodity. Imagine a woman named Linda in 1949. She is one of the millions of Americans who has just purchased her first television set. Before this, her knowledge of divorce was limited to the hushed gossip of her bridge club or the occasionally dry legal notices in the back of the newspaper. But now, she is seeing the private lives of Hollywood stars and high society socialites broadcast directly into her living room. The divorce of a figure like Rita Hayworth or the serial marriages of the era's leading men were no longer just distant scandals. They were blueprints for a new kind of social mobility and personal reinvention. This period marked the birth of the tabloidization of the decree. Historical trends show that as the 1940s gave way to the 1950s, the circulation of gossip magazines like Confidential began to skyrocket. These publications capitalized on the fault-based legal system we have been dissecting. Because the law demanded a villain and a victim, these magazines provided exactly that, often with photographic evidence that had been leaked by the very private investigators hired for the court cases. The potential outcomes for the American public were profound. For the first time, the average person saw that even the most idealized versions of the American family were susceptible to the same rot of infidelity, cruelty, and desertion that they were experiencing in their own neighborhoods. This effectively lowered the social barrier to divorce by normalizing it as a byproduct of modern fame and fortune. Step by step, this media saturation changed the strategy in the courtroom. Lawyers began to realize that the court of public opinion was just as important as the court of law. We see in the case studies of 1949 a rise in the use of press releases during divorce proceedings. If a husband could successfully frame his wife as a spendthrift or a neglectful mother in the local papers, he gained significant leverage in the settlement negotiations. The threat was clear. If you do not accept this meager alimony, I will ensure that every one of your friends and neighbors knows the intimate details of our domestic failure. This was the era of the weaponized reputation, where the privacy of the home was sacrificed on the altar of legal and financial victory. Beyond the celebrity glare, we must look at the academic data regarding the divorce of convenience in the late 1940s. As the Cold War began to settle into the American consciousness, the federal government started to link domestic stability with national security. The potential outcomes of being a divorced person in a sensitive government job were increasingly negative. We see in the historical records of the late 1940s that many federal employees chose to stay in hollow, abusive marriages specifically to avoid the red flag of a divorce on their security clearance applications. A divorce was seen as a sign of an unstable character, making an individual a target for blackmail by foreign agents. This created a unique sociological pressure where the state essentially incentivized the maintenance of a lie for the sake of the defense industry. Imagine if you were a scientist at Los Alamos or a clerk at the State Department in 1949. Your marriage has been dead since you returned from the war in 1945, but you know that filing for a decree will trigger an FBI background check that could cost you your career. You are trapped in a domestic purgatory by the very government you are trying to protect. This led to a rise in discrete separations, where couples would live in the same house but have entirely separate lives, sometimes even dating other people with the silent consent of the spouse, all to maintain the public image of the nuclear family. The data suggests that the stability of the late 1940s was often a hollow shell maintained by the threat of professional ruin. This period also saw the rise of the expert industrial complex. As the 1940s wound down, the influence of figures like Dr. Benjamin Spock and various marital counselors began to fill the void left by the declining influence of traditional religious leaders. These experts began to pathologize divorce as a medical failure. If a marriage failed, it wasn't just a legal issue, it was a psychological one. The step-by-step process of saving the marriage became a national obsession. However, this often placed an unfair burden on the wife. The academic literature of 1948 and 1949 is rife with advice telling women that they could prevent their husband's infidelity or combat fatigue by being more attractive, more submissive, and more efficient in the kitchen. The potential outcome of this advice was a generation of women who felt personally responsible for the systemic failures of a post-war society that had given them no tools for healthy conflict resolution. As we look at the financial data from 1949, we see the first signs of the credit trap in divorce. In the post-war boom, Americans were buying cars, televisions, and houses on installment plans. When a couple divorced in 1949, they weren't just splitting assets, they were splitting debt. Because the law was ill-equipped to handle the division of future liabilities, many divorced women found themselves legally responsible for the payments on a car their ex-husband had taken or a television they no longer owned. The lack of consumer protection laws meant that a divorce was often the first step toward a lifelong battle with creditors. This was the beginning of the divorce poverty pipeline that would define the economic reality for single mothers for the next several decades. The year 1949 also witnessed a surge in migratory marriage as a response to migratory divorce. People who had just received their quick decrees in Reno would often walk across the street and marry a new partner within the hour. This created a legal phenomenon known as interstate entanglement. Because different states had different waiting periods for remarriage, some required a year while others required none, a person could be legally married to one person in New York and another in Nevada simultaneously. The case studies from this period are a labyrinth of bigamy charges and inheritance disputes that would take the courts 20 years to unravel. The academic takeaway from the 1940s is that it was a decade of profound contradiction. It was a time of immense collective unity during the war, followed by intense individual fragmentation after it. The goodbye girl had become the Reno regular, and the uniform craze had been replaced by the divorce scandal. We see in the final statistics of 1949 that while the divorce rate had dipped from its 1946 peak, the number of unhappy but trapped households had reached an all-time high. The 1940s didn't solve the problem of domestic unhappiness, it simply drove it underground, where it would ferment until the cultural explosions of the late 1960s. But as the clock ticked toward midnight on December 31, 1949, a new and darker legal trend was emerging that would haunt the 1950s. The use of the morality clause in employment contracts. The divorce of the 1940s had become so visible that corporations began to realize they could control their employees' private lives through their paychecks. In the final part of this masterclass, we will look at how the 1940s divorce crisis led to a corporate takeover of the American family. We will explore the pink slips of the decree and how the decade of the 1940s ended not with freedom, but with a new kind of social surveillance that would make the previous 10 years look like an era of liberty. We are heading into the final chapter of this deep dive, where the lessons of the 1940s finally meet the reality of the modern age. The corporate takeover of the American family began as a direct response to the domestic instability of the 1940s. As the decade closed, major United States industrial and white-collar firms began to view a stable marriage as a prerequisite for corporate advancement. Imagine a man named William in 1949. William is an aspiring middle manager at a large chemical firm in Delaware. He is efficient, brilliant, and hardworking. However, William is also in the process of a messy divorce. In the late 1940s, this was not viewed as a private matter, it was a professional liability. Corporations began incorporating morality clauses into their contracts, which allowed for the immediate termination of any employee whose private life brought disrepute to the company. The historical trends show that divorce was often categorized alongside radical political affiliation as a reason for dismissal. This created a culture of corporate surveillance. Case studies from HR archives of the late 1940s reveal that companies would often send private investigators or corporate social workers to an employee's home to interview neighbors and assess the health of the marriage. The potential outcomes for someone like William were stark. If the divorce proceeded, he would receive a pink slip alongside his legal decree. This was the birth of the corporate wife, a woman whose primary role was to act as a social ambassador for her husband's career. If a woman in 1949 wanted to leave her husband, she had to consider that her departure would not just end the marriage, but would also end his ability to provide child support or alimony. This economic interdependence was used as a blunt force tool to suppress the divorce rate as the country entered the 1950s. The data suggests that this corporate pressure was one of the primary reasons for the statistical dip in divorces between 1947 and 1950. It wasn't that the psychological trauma of the war had healed. It was that the cost of exit had been raised to an impossible height. The step-by-step institutionalization of the family meant that the home was no longer a sanctuary, but a branch office of the corporation. This led to the rise of the secret life of the 1940s professional. We see in psychiatric records from 1949 a significant increase in stress-related illnesses among men who were leading double lives, maintaining a perfect suburban facade for their employers while navigating a separate, hidden world of extramarital affairs or secondary households. This brings us to the final academic pillar of the 1940s divorce crisis: the legal legacy of the fault era. By 1950, the United States was a nation of legal fiction. Every divorce required a lie, every custody battle required a character assassination, and every financial settlement was a gamble. The 1940s had proven that the 19th century laws governing domestic relations were fundamentally incompatible with 20th century life. The academic takeaway is that the 1940s served as the catalyst for the eventual no-fault revolution. Legal scholars began to realize that the current system was incentivizing perjury and rewarding the most aggressive and dishonest litigants. Imagine if the reformers of 1949 could see the current year 2026. They would see a world where the shame of the 1940s has been replaced by administrative efficiency. But they would also see that the fundamental problems identified in the 1940s, the economic vulnerability of women, the trauma of children caught in the crossfire, and the difficulty of navigating interstate jurisdictions, remain partially unresolved. The 1940s gave us the blueprint for the modern American struggle with intimacy and independence. It was the decade where we first asked if the state has a right to force two people to stay together, and the answer we gave was a resounding and complicated maybe. The financial breakdown of the decade also shows the emergence of the insurance gap. In the 1940s, health insurance and life insurance were tied almost exclusively to the male breadwinner's employment. When a divorce occurred, the woman and children were instantly cast out of the social safety net. Historical trends indicate that this lack of portable benefits was a primary driver of the reconciliation industry. Many women would stay in high-conflict or even dangerous homes simply because a divorce meant the loss of medical care for their children. This was the ultimate systemic failure of the 1940s, the privatization of the family's security. As we conclude this deep dive, we must look at the generational echo. The children of the 1946 divorce spike grew up to be the architects of the 1960s social revolution. Their desire for authenticity and their rejection of the hollow marriage of their parents was a direct response to the lies they witnessed in the 1940s courtrooms. The data shows a direct sociological link between the trauma of the post-war homecoming and the radical shift in family values 20 years later. The 1940s didn't just change the people who lived through them. They changed the DNA of American culture. We have explored the goodbye girls, the Reno ranches, the vanishing husbands, the coercive commitments, and the corporate surveillance. We have seen how a decade of global war turned into a decade of domestic combat. The academic look at 1940s divorce reveals a society in a state of violent evolution, a country trying to reconcile its Victorian past with its industrial future. The lessons of this era serve as a warning for 2026. When social reality moves faster than the legal system, the potential outcomes are always characterized by chaos, dishonesty, and the suffering of the most vulnerable. This masterclass has provided a step-by-step forensic analysis of how the American family was dismantled and rebuilt. We see that the traditional family we often romanticize was, in many ways, a legal construct enforced by the threat of poverty and social exile. By understanding the data, the case studies, and the historical trends of the 1940s, we gain the context to understand our own domestic challenges today. The 1940s was the century's most honest decade about the failure of the old ways, even if it had to lie to get the job done. But this is only the beginning of our journey through the history of the American home. While the 1940s gave us the divorce crisis, the 1950s gave us the response. A period of hyperconformity that created its own set of unique psychological pressures. The man in the gray flannel suit and the suburban housewife were the characters in the next act of this drama. And their story is even more complex than the one we have just finished. How did the survivors of the 1940s divorce spike try to protect their own children from the same fate? And what happened when those children discovered the secrets their parents had buried under the manicured lawns of Levittown? In our next series, we will peel back the wallpaper of the 1950s to discover the hidden epidemic of the medicated marriage and the rise of the first mass-marketed antidepressants that kept the American family together when the law no longer could. We are moving from the courtroom into the medicine cabinet, and the results are even more startling than the data we found here.